So, what's the Equal Protection Clause of the 14th Amendment anyhow? Well, it states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's pretty long, right? So what does it all mean? Basically what they're getting at is that we're assured no matter what you are, black, white, Latino, whatever, so long as you're American, you're entitled to equal protection under the law. What it isn't is any special protection for a single group. You're all the same under this clause, so long as you're a resident. So black, white, brown, man, woman, if you're a citizen, the law applies to you, same as everyone else. Well, that's pretty obvious, right? Why would we even need something like this? Well, the Founding Fathers had a slightly different idea of equality. Our society wasn't exactly the same sort of melting pot in those days. Things changed. Why edit the Constitution? Well, after the Civil War, the Civil Rights Act of 1866 was created to ensure that Americans were equally protected under the law, including the newly freed slaves, who previously hadn't been eligible for citizenship. When it came to defending the constitutionality of the first Civil Rights Act, it didn't seem to fit into the Constitution. There just wasn't space in there. So some work was done to remedy that. The Equal Protection Clause made it clear that all citizens should be equal under the law and redefined citizenship itself. That brings us to the Civil Rights Act, which deserves a mention here. Now, things obviously haven't remained static when it comes to defining the rights of different groups. That's where the Civil Rights Act has come in. Title VII of the 1964 version clarifies employment rights and offers us a rather important note in Section 703. It shall be unlawful employment practice for an employer, 1, to fail or refuse to hire or to charge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin, or 2, to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. Keep in mind, race, color, religion, sex, or national origin. This will be important later.